This morning on the Ag Issues program, joining us as he does every couple of weeks, Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine. Good to be with you.
Excellent. You know, start out with a different question. Just realized I don't think I've asked you this here in 2024. We talked about how long you've been on the program. How many years has this been?
I think we're just a year or two shy of 30.
30 years.
I'd have to go back and look for sure. It's over. Last time I checked, we were close to 800 programs. It was 700 and something. Yeah.
Wow. Well, I got a while to catch up for the number you and Kelly had, but I appreciate this program as well, and especially this time of year when we were talking about the previous year's top 10 developments in ag law and tax. In this case, for 2023, we did 10 through 6 or 2 weeks ago. So let's start with number 5 as we go through the top 10 list. And in this case, number 5 is the Corps of Engineers mismanaging the water levels in the Missouri River.
Yeah, this one was really big, Greg, this has been in litigation for a long time, and we came to the end of it in 2023. But what happened was back in 2014, there were about 400 farmers along that Missouri River corridor from extreme northeast Kansas up into South Dakota that claimed that they suffered flooding in 2007, 2008, 2010, 2011, 13, and 14. Because the Corps of Engineers released water into the Missouri River when it was already at a high point because of a lot of snowmelt out in Montana that had filled the river up. And this goes back to 2004 when the Corps had changed some of their language in their manual for managing the river to take into account what they thought they needed to do to comply with the Endangered Species Act and raise the water level in the river. Now, I'm oversimplifying it in the interest of time, but it's the change in that manual that the Corps was reacting to put more water in the river by releasing more from the Gavins Point Dam in South Dakota. And it flooded these adjacent farmland. And the farmers alleged that constituted a taking under the Fifth Amendment, which required the government to pay them for their lost property, lost crops, damage to buildings, those types of things. And ultimately what the court said was there was a flowage easement that the government had taken, and the government must pay them for that. The case was separated into a liability phase and a damage phase, and the court said, yes, the government is liable. And so now what we're back to is on the damage issue. And the court concluded that lost profit and the cost of moving into new facilities were not compensable under the Fifth Amendment, but that destroyed crops are. So that means crop damage, both mature and immature, has to be compensated because that's what was taken as a result of the Corps' taking of a permanent flowage easement. And so where we're at now is on remand back to the trial court to compute those damages.
Yeah, I think it was 2012, if memory serves, how many photos that we saw along I-29, really most of Nebraska, that I-29 was basically there, but then there was water basically all along I-29 based off of what we saw with the problems of the Missouri River.
Yeah, I-29, this occurred again in 2019. I-29 was shut down basically essentially between St. Joseph, Missouri and Omaha. It was an absolute mess. And I remember driving that route shortly after it was opened. And the devastation on the farmland there was just terrible. And then the stench was awful through there. And you could still see a lot of flooding even later in the fall of 2019 as I was traveling up to Fargo to speak, all the way up to that Iowa-Nebraska line and into South Dakota a bit. It was pretty bad. And 2019 was a rainy year anyway. The sandhills all across Nebraska. I remember making a trip to Montana and was angling up Route 2 through the Sandhills to get to Rapid City and then on up into Montana. And I'd never seen so much water in the Sandhills, and roads were closed. You had to take detours to get through. And there was a lot of water out there at that point in time. But this case was huge on the finding that the government had taken a flowage easement, and they have to pay for crop damage.
All right, let's move on to number 4. And this has to do in part for what we see through the pandemic, and that is the ERC, or known as the Employee Retention Credit.
Yeah, this was a mess of another kind. We talked about the water mess, but this was a tax mess. The ERC, what it was, as you indicated, it was enacted during the virus years, and it was enacted initially in 2020. It was modified in 2021. But it was enacted in 2020 to provide an incentive for businesses to keep their employees on the payroll, so retaining employees, hence the name Employee Retention Credit. And it could be a big deal monetarily, the way you would compute this. And it was a refundable credit, which meant that even if you didn't have a tax liability, the government would write you a check equivalent to the amount of the credit. One of the problems, Greg, with refundable credits is it brings the fraudsters out of the woodwork, whether it's a child tax credit, whether it's the employee retention credit, it doesn't matter. Refundable credits are prone to abuse, and because if you don't have a tax liability, you're going to get a check with taxpayer dollars subsidizing you. Well, the thing with this one is that you had to establish your qualifications for the credit, and the way you did that was to show that you had to shut down your business either fully or partially because of a government order. There was a state governor somewhere that ordered your business to be shut down, or you had a sufficient reduction in your revenue compared to the same quarter that you're measuring in either 20 or 21 compared to 2019. Well, if you think of farming operations did not shut down. We don't stop farming. We don't stop producing crops and livestock. And in 2020-21 compared to 2019, revenues from the vast majority of farming operations did not drop by the sufficient percentage compared to the same quarter in 2019 to claim the credit. So vast majority of farming operations not eligible for this at all. Well, in come the fraudsters pushing this, and you probably saw the commercials on TV or heard them on radio or saw them in magazines or got a text on your phone. It was so pervasive of these mills that were generating these credits, and they'd say, well, you're entitled to $50,000, $70,000 worth of credit. You pay us $5,000 or $7,000, we'll fill out all the paperwork. Well, they do that, and then they're gone. They're fly-by-night operations. They're gone. This got so bad in 2023 that the IRS said, we can't keep up with all of the fraud. We're shutting the program down. We're not processing any more claims starting with the fourth quarter of 2023. And then what we saw happen later in 2023 is the IRS created an amnesty program. And there were two pieces to that. One said that if you think you've received a payment or you have a claim that's been processed that you haven't received payment for yet, let us know, and there's a process you can go through so that we won't come after you, or you can send the money back, or whatever the case might be, wherever you were at in the process. And then that turned into a voluntary disclosure program, which is still open through late March. You can participate in this. And what they're saying is if you got a credit, which now you know you weren't entitled to, you can pay a certain portion back, just keep the balance, we'll leave you alone. So that's how bad this was. I've never seen a credit abused like this ever. And a lot of farming operations got caught up in this. So the lesson on this one is be careful with these refundable credits, but there is still an opportunity to keep the IRS off your back if you participate in this voluntary disclosure program.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law. Well, we've hit 5 and 4, so let's get to the top 3. And let's start out with top 3 with our friends out in California. And it's California's Prop 12 at the U.S. Supreme Court.
Yeah, Greg, this I think probably many listeners can probably closely predict what the top three are going to be, if not the three, but at least the top one. But Proposition 12 made it to number 3 on my list, and that, of course, is back in 2018, where California voters said that you can't sell pork-based products in the state of California unless you can certify that the hogs from which the pork products derive were raised in a manner that complies with California's standards and their regulations. And that got challenged and went all the way to the U.S. Supreme Court, and it involves something known as the Dormant Commerce Clause, where Congress hasn't acted on something. Can the states regulate that? And it's a tangled way in which the courts evaluate this. It's a complicated way that this is done. But the court, in a 5-4 plurality opinion, dismissed the case for failure to state a claim. They said it was so badly pled by the groups representing farmers in this one, basically the pork industry, that they couldn't even hear the merits of the case. Now, that didn't prevent them from issuing multiple opinions in the case, but they never got to the merits of the case. In fact, Justice Kavanaugh wrote separately and gave a biting criticism of the lawyers for the pork producers by stating, quote, "It appears, therefore, that properly pled Dormant Commerce Clause challenges under Pike to laws like California's Proposition 12, or even Proposition 12 itself, could succeed in the future, or at least survive past the motion to dismiss stage," end quote. That's a big ouch. Learn how to properly plead a Dormant Commerce Clause case is what he's saying, and you might actually win. So this one was botched from the start, and it never squarely got in front of the court so they could decide the case. And here we are. We're left with this opinion, which allows California to dictate the way in which pork is raised in states other than California. So we shall see what happens with respect to this. I don't know if this will get into the Farm Bill debate. There was an attempt to do this back in 2014, but it did pass the House. It didn't make it through the Senate. And there was a push in 2023 by some senators that opposed the legislation in 2014 to include it in an upcoming farm bill, perhaps, or on standalone legislation basis. But this was a bad one for agriculture and for the pork sector in particular in 2023, but a big one.
I would ask if this is far from over, but I think those questions still need to be answered depending on legislatively or another angle that this may go?
Yeah, I think the answer to this one, well, two of them. One, when you look at Kavanaugh's opinion, the industry needs to learn how to plead properly a Dormant Commerce Clause case and argue it. I listened to the oral arguments, and it was stunning to me how bad it was. It was awful. But secondly, I think more importantly, the Congress needs to deal with this. If we're concerned about one state dictating agricultural production methods in another state, well, see if you can come up with some legislation that satisfies that issue and satisfies the Constitution at the same time. So it's going to require the threading of a needle to satisfy both of those, but it might be able to be done. We'll see what happens. Maybe it'll be part of the debate of the 2024 Farm Bill.
Number two in this is something that has been going on for quite some time, and I think it's got a long tail yet ahead, and that is the foreign ownership of agricultural land.
Yeah, that was certainly a huge issue in 2023 with numerous states. There was action both at the state and perhaps there was attempts made at the federal level, but the action was largely at the state, with a number of states adopting new rules concerning foreign ownership of agricultural land. And, of course, there were a number of things that had happened recently to put that in the forefront of legislators' minds. And the big action basically occurred in Florida and Arkansas. And we even had a case, a court challenge with respect to the new Florida law, and it was upheld as constitutional. So that all happened in 2023. And in Arkansas, we saw in the new law take effect, and then in October, the governor of Arkansas became the first one in the nation to enforce a state foreign ownership law by having the Attorney General order a subsidiary of Syngenta Seeds, which is a company owned by an arm of the Chinese Communist Party, to divest its ownership interest in farmland it owned in the state of Arkansas. And there were other states that enacted about a dozen states, and then so far in 2024, we've had another dozen states already propose legislation in their legislative session. So it's an issue, and it's still an issue that's before the Kansas legislature right now.
Well, as we go to the number one development in ag law and tax in 2023, I don't think a big surprise. Of course, it has been the development out last year concerning the waters of the United States, or WOTUS rules.
Yep, the Sackett case decided on May 25, where the court said that the Sacketts, who owned that lot in northern Idaho, the court unanimously said that that was not a wetland. It was about 100 yards away and drained into Priest Lake, which is a navigable water of the United States, runs 19 miles long, very beautiful area of northern Idaho. But they said unanimously that there was not a wetland because there wasn't a sufficient connection to a water of the United States. And what we got out of Sackett was a new way, or actually a reversion to the old way, in which we evaluate whether a particular wet area is jurisdictional by the federal government. And the court said there has to be a continuous surface flow that connects that wet area by that continuous surface flow to a navigable water of the United States. And as for the 2023 current administration's WOTUS rule, the Supreme Court said, well, that's inconsistent, and I'm quoting them now, inconsistent with the text and structure of the Clean Water Act. And that's the end of the quote there. So they wiped out the current administration's rule, essentially going back to the Trump rule, and they said that that is more consistent with what Congress intended. So that was actually a big win for agriculture. We will see if the administrative agencies in their new rule, which has been challenged, we'll see what the further litigation says with respect to that. But don't expect this one to be over. I expect more litigation on this out into the future, including 2024.
In other words, in about a year from now, when we have this same program, it wouldn't probably surprise you that some of these are going to be, again, on this list and as we look at the top line developments in 2024.
Yeah, I think that's probably safe to say. These are so high-profile items that they will continue legislatively or in the courts as we go through 2024. So I wouldn't be surprised if we're talking about some aspect of the same issue on a couple of these next year this time.
Okay, sounds good. Roger, as always, I very much appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law. Yes, he has been our guest on the Ag Issues program here on 580 WIBW.